legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1.3 states that sovereign power is delegated to specified organs, state organs, including parliament and the legislative assemblies of county governors. Moreover, Article 94.1 of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149(1) is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even were one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercise their votes. We are therefore satisfied that this openness and transparency, which is the constitutional core of Article 118(1)(a)'s requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64(2) and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64(2), contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. They thus prayed for a declaration that Standing Order 64(2) is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Order 64(2) and 5, contending that they are necessary for the expeditious conduct of impeachment proceedings. They pointed to the Constitution itself as a source of the condensed timelines, including Article 145(2)(a), which requires the Speaker to notify the Senate within 2 days, Article 145(3), which requires the Senate to convene within 7 days, and Article 145(4), which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urged the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is trite that standing orders are subordinate legislation, deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes the procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days, encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia, Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondently be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus the Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64-2 unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Minor Kai and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64-2 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do